I appreciate you joining today. You know, a lot of times in people's lives, things happen, and people are sometimes kind of a little bit hesitant to call someone to help out. But when you have something going on in your life, a legal issue, you need to get some legal help because it's very important. There's a lot of content online right now that I think isn't really worth, a lot, but content about getting you out of legal problems or helping you with things like divorce or bail on a criminal or federal case or a workman's comp case. These things are stuff that you need to talk to an attorney about. And I have one of the finest attorneys in the whole state of Alabama here to help us out. It's Joseph Ingram, and I appreciate you coming, Joseph. Thank you very much.
Thank you, Kent. Enjoy being with you today.
So first thing I think I want to cover is how to modify a divorce decree. So you want to go back into court and you want to change things. How do you do that?
Well, what I'd like to talk about today is just to give some people some good information. I get calls all the time. People will say, I want to go back to court, modify my divorce decree. How do I do that? And primarily there are four main issues that people go back to court to modify a divorce decree. And those are for child custody, child support, child visitation, and post-minority support, which means going back to the court and asking that your ex-spouse help pay for college tuition before the child turns 19, which is the age of majority in Alabama. I'd like to talk a little bit about each one of those because I think all four of those are important topics for families. Child custody. Let's say that you are a father and your children are not being taken care of. The home is not in good shape. The mom's not taking the kids to school, not taking care of health care. Dad may decide to go back to court and ask for child custody of the kids. In the state of Alabama, we follow a standard which is called the McClendon standard, which is basically the court case name. And what that means is it is up to the father and me, if I represent the dad, to show that it is in the best interest of the children to remove the children from the mom and give them to the dad for him to be the custodial parent. Those cases happen all the time and they're very winnable. But what I'd like for people to know and for education purposes is that it is important that we show, it's our burden of proof to show that it's in the best interest of the children to change custody.
Okay, very, very good. Could you speak just a little bit louder, maybe get up to the mic just a little bit closer? That'd be great. I'm picking you up, but just a little bit at a distance. So.
Okay.
So yeah, that's much better. That's much better. So what's the process that you have to go through in order for this to happen?
The process in the state of Alabama is you file a petition to modify a divorce decree. It's just like a new complaint. You pay a court filing fee. Your ex-spouse is served with a copy of the complaint, and in 30 days they file an answer. Generally speaking, if you're filing for a change of custody, those are not what I call cases that can be settled. Generally, those are going to be a trial. You can't split children like you can money. Children aren't divisible. So you're usually going to end up having a custody trial. And those take a little while to build and develop your case for trial. You may have to take expert depositions. You may need to get records related to counseling sessions if they've been to a counselor. You may need to get school records. If the mom has any type of criminal record or the father has a record, you may need to get police records. So these cases take a little while to develop before they're ready to go to trial.
Okay, that's much better. I can hear you a lot better, clearer too. So what would be your final advice for somebody that's feeling that they need to have this done? I mean, at what point does it tip over to where you think you need to make an action? I mean, I just don't know how, what would be the thing that you would say, the best advice you would give somebody? If I were sitting there talking to you about this today, how would I make that decision, whether I want to go and do that? And if, is this happen fairly regularly where you do get these changes in these, or do they pretty firm about when it's originally stated that they don't change things? How does that work?
Well, I would tell anybody that these are on a case-by-case basis, child custody cases. There's not any rule of thumb. You know, a lot of times you'll hear Kent, parents will come in and they'll say, well, my son or my daughter is a teenager now and they want to live with me. And there's this perception in the community that if a child says, I want to go live with mom or dad, that's an overriding decision for the court to consider. And as a matter of fact, I had a case like this just on point in the last year. The case law in Alabama says just because a teenager voices an opinion that they want to go live with mom or dad is not the deciding factor in a change of custody. The deciding factor is what's in the best interest of the child. But, you know, these cases are winnable. Anytime you feel like your children are in danger or not in a good environment, that's when it's time to pull the trigger and go file a petition to change custody.
Okay. Now, what if you're in a situation like this, but there never has been a formal marriage? Can you still go back and get these things done?
Well, the process would be a little bit different. You would file a case in family court asking for custody of the child, but the best interest of the child would still be the same. You just wouldn't be filing it in a divorce action. It would be in family court. Yeah.
Okay, very good. So I think the other thing you want to talk about is the difference in bail between a state and a federal court, correct?
That's correct. This is an important topic. I get calls a lot for people that are about to be charged with a crime or about to turn themselves in federal court. And they'll call and ask me, should I go get a bail bondsman? Should I pay for a bail bondsman to get out on bail? And I tell people, if you're charged in state court, if at all possible, do not pay a bail bondsman. And here's the reason why. They do serve a purpose, and I don't have anything against them as a profession. Let's say you have a case and your bail is $15,000. You have to pay a bail bondsman 10% of the bail to get out of jail, which would be $1,500. The bad part about that is you don't get the money back. That's money that you guarantee that you're going to show up for court. So that's just like throwing money out the window. So if at all possible, if you have family members that live in that county that can put up property and post what we call as a property bond, I always encourage people to do that. Because the more money you spend on getting out on bail is less money you can use for your defense. And let's face it, anybody that's ever charged with a criminal case, you want to spend your money wisely to defend yourself. So that's why I'm against bail bondsmen. In federal court, there's some good things about getting out on bond in federal court. Federal court has three types of bond that they use. They have what is called a signature bond, which means literally you walk in and sign your name to a piece of paper, and the values can be from $5,000 to $50,000. And it's just like signing a note to the U.S. government. I, Joe Ingram, agree I will show up for every court hearing after that. So it's called a signature bond. The second way you can get out of jail in federal court is called electronic monitoring, or what everybody is referred to as an ankle bracelet. And you're sort of on home detention in that regard, Kent. You have to get permission to leave the house, and they literally can monitor you by GPS tracking. And then the third way in federal court to get out is what we refer to as a third-party custodian. You are actually released into someone else's custody. Let's just say, for instance, I was charged in federal court with a crime. You came in and said, you tell the judge, I will be responsible for Joe as his third-party custodian. You sign a piece of paper to the federal government saying I'm responsible for him. So if I take off, here's the bad thing. They're going to come looking for you, the U.S. Marshals, until they find me. So some people are a little hesitant about being a third-party custodian unless they're a family member.
It's good information. I didn't know any of that. So how do people get charged in federal court versus state court? What kind of crime do you have to do in order to get charged in federal court versus state court?
Good question. Almost every case that is charged in state court can be charged in federal court. You can literally be charged in state and federal court for the same crime. It happens all the time. I'll give you a good example. Let's say someone gets charged in state court with having a handgun and not having a permit, and they go and plead guilty to that, which is a misdemeanor in the state of Alabama. The federal government has 5 years to charge you statutorily for having a gun without a permit. And usually they'll pick these cases up 2 or 3 years later, and there's almost no defense in federal court because you've already pled guilty in state court for the same crime. And it's not double jeopardy. It's completely different crimes. It's completely different sentences. But most of the cases you see in federal court are felons in possession of a firearm, drug cases, illegal immigration cases. People come here illegally and they commit a crime. So they get charged with being here illegally and committing a crime as an illegal alien. But almost every case that you can think of that is a crime in state court is also a crime in federal court.
Okay, and what about, like, I've heard about these mandatory statutorial penalties that are placed in state or federal court too. How does that work?
Yeah, the federal courts use what we call the United States Sentencing Guidelines. And all that basically means is your sentence is based upon 2 factors. Every crime is given a value as to the seriousness of the crime. So, having a gun might be in level 12. The guidelines run from 1 all the way down to 36. 1 being a very minimal crime, 36 being a very serious crime, which might be the death penalty in federal court, like the Boston guy that was charged with the Boston Marathon recently. He had a federal death penalty. And then the other value of the guidelines is based upon your criminal history. So if you have never been charged with a crime, you never had a felony, your criminal history would be a 0. For every felony that you have in your past, you're given 3 points on your criminal history. So it's sort of like a grid chart, Kent. You look at the seriousness of the crime, and then you look at your criminal history, and that tells you what your sentence would be in federal court. And the good thing about that is it doesn't matter whether you're charged with a crime in Alabama, Mississippi, Atlanta, or even in California where you are. The federal guidelines are standard throughout the United States. That's the good thing about the federal guidelines.
And if you have too many of these federal felonies, then you can face some pretty stiff penalties, correct?
That's generally correct. If you have 2 felony convictions, and let's say you pick up a 3rd case for a firearm conviction, then a mandatory sentence kicks in, which would be a mandatory minimum of 15 if you're convicted. That's correct.
Wow. So you want to make sure you fight every one of these to the best of your ability because they start to accumulate, right?
That's correct.
Okay. And are the sentences, as far as your sentences are concerned, are they strong? Do you get more set time in federal court and state court, or are they pretty similar?
Well, generally speaking, federal court sentences tend to be a little tougher than state court. Here in Alabama, as in most states in the country, and I know in California, you guys are fighting this out there as well. We absolutely have overcrowding in state prisons. So they have developed a new standard of felonies in Alabama. Alabama used to have A, B, and C felonies. Now we've developed a Class D felony to try to keep people from overcrowding the prisons. And the thing about federal court, the sentences tend to be a little tougher. And where I am in Alabama, the judges are extremely conservative, and the sentences tend to be very, very tough if you go to federal prison.
Yeah, so you want to make sure you get a good defense going. So So, and the other, I think the last topic you wanted to talk about is you want to talk about workman's comp and that's why you need a lawyer in order to have it when you've been injured in a workman's comp case.
Yeah, I get these questions asked a lot of times. Someone will get referred to me, they've been hurt on the job, and they'll call me and they'll say, why do I need a workman's comp lawyer? And what is this going to cost me? And the good thing is that it doesn't cost you a dime to have a lawyer represent you in a workman's comp case. I only get paid if there is an award for a person being injured that gets compensated by the company. And it's a statutory cap on the award. Alabama law says that the most that a lawyer can receive on a workman's comp case is 15% of any settlement award. And, you know, workman's comp cases are very common. I always grew up, I don't know if you ever heard this growing up, Kent. My parents used to tell me, if you get hurt on the job, don't tell them because they'll fire you. I don't know if you ever heard that. You know, that's not necessarily true. If you get hurt on the job, you do need to tell your employer. Because if you get hurt, and let's say you hurt your back, and you're not able to work in 2 or 3 years, you're really not going to be able to take care of your family. And so that's why it's important to file a workman's comp claim. I tell people all the time, if you get hurt, you report it immediately to your supervisor. If you can't report it to your supervisor, report it to a fellow employee what happened. Because the duty is on you as the employee to file what is called a first report of injury, to put them on notice that you got hurt. And then after you got hurt, then your employer, if they believe that it's a legitimate claim, they have the responsibility to pay to send you to the doctor to get checked out. And the thing about this is the employer has the decision where they send you for medical treatment. You can't say, I want to go see my general practitioner. You have to go where they send you for medical treatment.
Okay, and as far as injuries are concerned, is there certain caps on certain injuries, or how does that work?
Most injuries in Alabama are what we call scheduled member injuries. They've put a value on your finger, on your hand, on your arm, on your shoulder. Every part of your body is what we call a scheduled member, and it has a value under the workman's comp guidelines. However, there are some parts of your body that are what we refer to as a non-scheduled member. That would be your back. That would be your neck. Things that would have a lasting effect on whether or not you're able to ever work again. You might be permanently, totally disabled from this injury. In fact, I've had a number of cases in the last 2 or 3 years where a judge has determined a injured worker to be what we call a PTD, permanently, totally disabled. And at that point, you receive compensation for the rest of your life.
Okay, so I can see why you need a lawyer for this stuff. You need to be able to present the case in such a way that the court sees what it is that you're trying to achieve. So let me ask you another question. How far out does your practice reach? And is your office primarily in Birmingham, or do you have offices outside the area?
My office is located in Birmingham, but we represent people throughout the state of Alabama, Huntsville, Mobile, Montgomery, Dothan, Alabama. We represent people statewide. And as far as federal court, we represented people in Atlanta, represented people in Florida. In federal court, you could represent people in any jurisdiction.
Okay, and so how's a good way for people to get a hold of you when they need your help?
Best way to reach me is go to my website, joeingramlaw.com, or they can call me on my cell phone number, 205-335-2640. We have people that answer the phone 24/7. We return all calls within 24 hours.
Well, that's good information. So before we leave, is there anything else you'd like to add to any of these topics?
No, I think we're good. I enjoyed our conversation. Thank you.
Well, I appreciate you joining me, and I'm sure everybody else appreciates it too. I mean, did one earlier about divorce, and I had a lot of comments. A lot of people left comments, and not only that, a lot of people called me and told me that they enjoyed it. So I appreciate it, and I really appreciate your time because, like I say, people need to know this information. People need to know, and that's why I like to bring these to people so they can get an opportunity to hear somebody that is giving them the straight truth about it.
Well, always enjoy visiting with you, and I hope it's educational for people more so than anything. Education is power, and so I always enjoy sharing information with people so that they can make the best decision in their lives.
That's correct, and a lot of these decisions that get made, especially when you're in a divorce or if you've been charged with a crime, these are life-changing decisions. So you have to really be careful about what you do and make sure that you investigate all your different the alternatives as far as what could possibly happen, because they could make a big difference in your life.
That is true. These are life-changing decisions.
Okay, well, I appreciate your time, and we'll probably do it again, not too much in the future. So thank you, Joseph. Thank you very much, and have a great day.
All right, kid. Take care. Bye-bye.
Yeah, thank you.